If you've hired a criminal defense attorney, or if you're considering it, there's a good chance that you've been told that your attorney's private investigator is handling the investigative side of your case, that the PI is out there gathering information, tracking down witnesses, building the factual record that your defense needs. I want to tell you what that private investigator is actually doing, because the reality of how criminal defense private investigators work is significantly different from most defendants understand. And there's something that your attorney almost certainly has not told you, not because they're hiding it, but because they have no obligation to raise it and every reason not to. My name is Michael Quiel. I'm the CEO of the U.S. Observer, an investigative newspaper and advocacy organization that has produced over 1,200 vindications since 1991. I spent 15 years as a federal defendant, and what I'm going to explain in this whole video is not an attack on defense attorneys or their investigators. It's a precise description of the lane that they work in and the lane that remains open when they are done. What a defense PI is actually hired to do. Here's the first thing that you need to understand. A defense attorney's private investigator does not conduct an independent investigation. They investigate exactly what the attorney tells them to investigate and nothing more. This is not a criticism of the investigator. It's simply how the relationship works. The attorney directs the PI. The PI produces what the attorney needs for the legal strategy that the attorney has already decided to pursue. If there's a witness the attorney wants located, the PI locates them. If there's a document trail the attorney wants verified, the PI verifies it. The scope of the investigation is defined entirely by the attorney's existing theory of the case. If there's something relevant to your defense that falls outside the attorney's current theory, the PI is almost certainly not looking at it, not because they're negligent, but because no one has told them to. The funding problem in court-appointed cases. The constraint is even sharper in cases involving court-appointed counsel. Judges often control the funding for investigation in court-appointed cases, and the judge almost never approves the level of investigation funding that complex criminal case actually requires. The defense attorney may know what needs to be done. The PA may be capable of doing it. But if the court does not authorize the expenditure, it does not happen. This is a structural problem, not an individual failure. Federal public defenders and appointed private attorneys are often skilled and dedicated, but they are working within the resource constraints that the prosecution does not face. The government's investigative apparatus, its agents, forensic resources, and support staff operate without per-case budget cap. The court-appointed defense does not have that. Defendants who assume that the investigation into their case is often comprehensive often find out too late that it was bounded by what the attorney had time and funding to pursue, and nobody told them otherwise. The rule your attorney cannot work around. There's another layer to this that goes beyond investigators. There's ABA Rule 3.6 that restricts attorneys from making public statements or enhancing their case in the public by using the press. In practice, this means your defense attorney is legally constrained in their ability to publicly challenge the prosecution's narrative, call out the misconduct, or apply the kind of pressure that changes the environment around a case before it reaches a courtroom. Your attorney knows things about your case that, if published, could change how the prosecutors, potential jurors, and the public understand what is actually happening. They may know the government's star witness has credibility problem. They may know evidence was handled improperly. They may have documentation that puts the charges in a very different light. They cannot simply publish that, not without taking risks at their bar license. And here's the part that most defendants never hear. Your attorney is not required to tell you that public pressure is an option that somebody else could exercise. The restriction is on them. But the fact that the restriction exists does not mean the option doesn't. It means it falls outside their lane, and most attorneys will never raise it. What my first attorney told me, I want to be direct with you about something. My first attorney, early in my case, was a D.C. lawyer. He looked at the charges, looked at the government's leverage, and told me to plead guilty because they were the big bad government. His exact words were, "Son, that's the way it's been, and that's the way it always will be." He was a former federal prosecutor. He had relationships inside the system that he was not willing to burn. The advice he gave me was shaped in much by those relationships as by the facts of my case. I did not take the plea, but what that attorney never told me, not even once, was that there were tools available outside the courtroom that could be used to change the dynamics of the case before it ever went to trial. He had no reason to raise it. He had no obligation to raise it. And raising it would have meant pointing me towards something that does not benefit him professionally. The gap between what an attorney can do and what they are willing to say is possible is one of the most dangerous silences in the criminal defense system. The 7-year question that never got asked. I want to give you one more example from my own experience. It took me 7 years into my prosecution to get the IRS agent who worked in the case on the witness stand. 7 years. And when that moment finally arrived, when they finally had the person who had been central to building the case against me sitting in front of a defense attorney who could ask them anything, my attorney did not even ask the key question. He had worked with her at the IRS. He knew her. He had a prior professional relationship with her. And in that moment, when the question most relevant to my defense needed to be asked, his history with her pulled him in a different direction that my interest required. I'm not calling this corruption. I am describing something more common, more difficult to protect against. The ways in which an attorney's relationships, history, and constraints shape what they will and will not do on your behalf without ever telling you those facts exist. What actually fills the gap. I want to be clear about what this video is and what it's not saying. Defense attorneys are essential. The legal dimension of a criminal case requires someone who understands the law, knows how to file right motions, and can navigate the prosecutorial system that governs what happens in a courtroom. None of what I have described here changes that. What I am saying is that the legal defense is one dimension of a flight that has multiple dimensions. The attorney handles what happens inside the courtroom, but there is a dimension outside it, in the public record, in the information environment, around the case where the attorneys are either restricted or not positioned to operate. That is not a gap your attorney will typically name. This is a gap that has real consequences. The U.S. Observer works in that gap. We investigate independently, not directly, by your attorney existing theory. We document what we find and publish it under the First Amendment protection. We distribute that documented truth to the community, to potential jurors, and to the prosecutors who are watching what becomes public record. We have been doing this since 1991. The results exist because the gap is real, and the filling it changes the outcome. The most important question to ask right now, if you have an attorney on your case, your next question should not be whether they are good. Assume that they are. Your question should be, what is happening outside the courtroom that my attorney cannot do and hasn't told me is possible? If the answer is nothing, then you may be leaving the most powerful tool in your defense sitting on the table. If you're dealing with federal charges or helping someone who is, and you want to understand whether your situation is one where the U.S. Observer can help, reach out through our website, usobserver.com. There is no obligation. I am not going to tell you what a lawyer tells you. I am going to tell you what a 35 years of watching cases win and lose looks like from the outside in. I am Michael Quiel. Subscribe if you have not. I will see you in the next video.